Hi, everyone, and thank you for joining us for part 3 of our financial planning series. Tonight, I am joined by Vlad Portnoy, who is going to be covering estate planning, wills, trust, power of attorney, all of that good stuff, super relevant to what is going on in the lives of individuals and families with spina bifida. So Vlad, I'm going to pass it to you. And guys, if you have any questions throughout, please use the chat feature and we will get to those at the end. All right, thank you. Go ahead, Vlad.
Thank you, Julia. Thank you. Good evening. It's great to see everyone. Hope everything's going well. I wanted to give a primer to everyone about the key estate documents that everybody should have to at least the minimum degree. So what are we talking about? We're talking about estate planning. We're talking about Medicaid planning. We're talking about special needs planning. In general, there's various reasons to do all of these documents. Some of them qualify someone for government benefits like Medicaid. Some of them just preserve the legacy, as the slide says. Some of them are to alleviate potential infighting within the family. Whatever it is, it's better to have these documents and maybe not use them or not use them for a while than not have them and not be able to create them when the time comes. Let's proceed. So what is a will and what's an estate? When we're talking about estate planning, we're talking about everything that a person owned at the time of their death. Owning the assets means that their assets are under your name, but more specifically, they're registered under your social security number, because you can change the name, but it's not that easy to change your social security number. So in that aspect, when someone passes, the assets are divided into what's called probate and non-probate assets. Non-probate assets are the ones that pass by operation of law, something like joint property or retirement accounts. Probate assets are the ones that absolutely have to be considered as part of the estate and taken through the probate process at surrogate's court in order to change beneficiary from the decedent to the beneficiaries. The middle part is before the beneficiaries get their share, the executor of the estate must pay the creditors, and that's very, very important. And this is why, and your biggest creditors are the IRS, Medicaid, other government agencies that may have extended some benefits to you, and that's very, very important also. In general, estate assets are consistent of real property, which is condos and standalone house. The co-ops, interesting enough, even though people live in them just like condos, are considered to be personality. They're considered to be personal property like money because it's shares. But for for our purposes, we're going to consider them real property because it's an apartment unit, and for the planning purposes, it takes the same amount of effort and steps to transfer the co-op as condo. But this nuance does come to play sometimes. Tangible personal property is anything that is cash or can be liquidated into cash. For example, cars and furniture and savings and checking accounts, things like that, and CD accounts past maturity date that you can actually do something that not locked in anymore. And then there's intangible property, such as there's life insurance, there's IRA. So the life insurance, for example, and the IRA pass by operation of law if you have beneficiaries, which you are intended to have. Unfortunately, a lot of people forget or kind of omit for any reason adding those beneficiaries to life insurance, for example, and the IRA 401k, and then those assets for the lack of a beneficiary become part of the estate. This is why intangible property is included in here as an estate, even though it's not meant to be. And it's actually the worst thing that you can do is forget to add the beneficiary to a retirement account because the tax consequences could be a lot more severe than if it goes straight to the beneficiary. Keep that in mind. It's very important. What's a will? A will is a general document. It's a directive that basically tells literally it's a last will and testament, not to be confused with the living will, which we'll discuss in a second. It shows the decedent's literally last will of how they want to distribute their assets, which means which means they have a specific order of things and who gets what and what share, which is very, very important. Without it, you have the alternative, which is called the rules of intestacy, and that is prescribed by law. And your assets upon your death may end up with someone by law that you wouldn't otherwise want want them to end up, or some people may be less happy than others to receive a lesser share or something they weren't expecting. So there's bound to be infighting, literally family members, close family members fighting over your casket at your funeral. If that's a pretty vivid visual, but I've seen this happen. So you always, and the will doesn't really own anything. The will is a directive, and it says anything I own at the time of my death will be distributed this way. And that brings us to the previous slide where it says that's an estate. Literally, the will says my estate, everything that we just discussed, will be divided in such and such shares. You want to obviously, a will serves many other different purposes also, because if your beneficiaries are minors, you need to make special provisions that you will not be able to make anywhere else. If your beneficiaries are persons with special needs, again, it's something to the will by appointment of guardian or making a testamentary trust, and making sure that the beneficiary doesn't get their share outright and thus jeopardizes their public benefits. So a will is a great vehicle to make your wishes known and for you to account for your beneficiaries, considering where they are in life and what their needs are. What is a trust? A lot of clients come in and they say, I don't know what I want. I have this and this assets, and do I need a will or do I need a trust? And the answer is they're not mutually exclusive. A trust is a supplement to a will. You can have a will, and that will be a starting point, but it may not give protection, again, as we said, to people who are minors or special needs that will receive the money, and then money will go straight back out to creditors. But at least the will is your starting point. And again, the will doesn't control anything. It just provides guidance. It provides a specific scheme to how you wanted to divide your assets at the time of death. A trust is a private agreement that acts sort of as a holding company. So a trust also has provisions of how you want to divide your assets, where you want everything to go. But this is a private document that actually physically controls the assets. It's called funding the trust. Anything that you don't want to go through court, you put into a trust, and then upon your death, the trustee of the trust distributes this money outright to the beneficiaries, which is fantastic, which is great. Also, as we discussed earlier, probate and non-probate assets, when you fund an asset into the trust because it no longer goes to probate, it becomes a non-probate asset by definition. This is a great vehicle, amazing vehicle for anyone who wants to bypass the probate completely or minimize the value of their estate during the probate process. It also is an amazing vehicle for parents to protect their loved ones, protect their minor kids, protect their children with special needs, even when parents are of age that they can no longer physically take care of their loved ones. Well, not necessarily parents, any members of the family. We're just taking it very bare bones, very basic concepts. So a will, when it goes through probate, is a public document. Anyone can walk into a courthouse and pull your will and get everybody's name and see what everybody's getting. And it's just out there in the open. So a trust is also possibly, a great way to protect at least some part of the estate, if not all of it, and just minimize the exposure, and whatever is in trust is not going to be published to the, not going to be known to the public. There's also, depending on the size of the estate, there's also tax advantages. And obviously, there's a lot of trusts that are being utilized and widely used for persons with special needs, that are receiving public benefits like exemptions, tax exemptions, SSI, and Medicaid. The trusts there are two basic types of trusts: revocable and irrevocable. The basic differences, and then there obviously each of them has so many variations, but the idea is that why is it important? Revocable trust is where you as a grantor retain control over all the assets in the trust. The only thing that it does, so nothing changes for tax purposes, nothing changes for asset protection. Any creditor coming after you during your lifetime can also reach into your revocable trust, which is very, very important, because people say, oh, I have a trust. I don't know what it is, but it's in a trust, so it's protected. Not necessarily. So a revocable trust, you are in control. You are the grantor, you are your own trustee, which is like a manager of the trust, and you are the primary beneficiary. So anything if you put $10 into the trust, you can pay out of the trust to anyone, including yourself, but any of your beneficiaries and loved ones and friends and family, just like you could take the money out of your pocket and just hand it to them. So nothing changes. But why? So then if nothing changes, why does a trust exist? Revocable trust is called a will substitute. It literally serves one purpose. Anything that's in it bypasses the probate, but which saves you a lot of time and money. And also, depending on the county that you're in, especially New York State, it could be difference of many thousands of dollars in legal fees and months and years in having this matter stuck in the court. Some counties are more efficient, some faster, some are slower, and it creates, while it's being processed, it does create family tensions, and it creates tensions between you as a client and your attorney, because you should have been done by now, but sometimes it just takes a long time. So revocable trust is you retain full control, but you don't get any protection. In either of those situations, you can't have both the control and the protection. If you have control over assets in revocable trust, then your creditors can reach into the revocable trust as well as your own pocket if they have an issue. So this is not for revocable trust is usually not for persons with specific creditor issues or public benefits or anything of that nature. Irrevocable trust is, again, there's variations that are done for millions of reasons, and then specific ones. The most popular reasons are protecting generational wealth and not having the kids get the money at 18, kids and grandkids, and just squander the money, squander the opportunities that the money presents. There is tax benefits to having to relinquishing control, at least to some degree, or most of the degree, or all of it, depending on the circumstances, but protecting the money and passing it all to the next generation. And then there's obviously public benefits. Qualifying for Medicaid is a big deal. And in this cases, irrevocable trust is the way to go. So if it's for you, you would relinquish control of the asset by transferring into irrevocable trust, where someone else who is not you is controlling the asset. When it comes to your primary residence, you could actually, you have a right to occupy it until the end, until the end of your lifespan, and then it goes to your beneficiaries, bypassing the court. Obviously, there is subject all of this plan is subject to statute of limitations, because there's something that's called look-back period in both SSI and Medicaid, and you want to make sure that you transferred the asset into this trust within a specific period of time, and nothing happened in between. For example, nursing home Medicaid in New York has 5-year look-back, so just transferring your house into the trust is not enough if you go into nursing home within the 5 years from the date of transfer, because that the consequences could be potentially reversing the whole thing, or having something else happen that is very negative and unpleasant, and losing this opportunity. So this planning has to be done years and years in advance, at least 5 years. Currently in New York, there's no look-back period, but New York is really kind of in a vast minority in this, because most states, for example, New Jersey, have 5-year look-back on both community Medicaid and nursing home Medicaid. So even to go on community Medicaid in New Jersey, you still should have done this 5 years ago, then waited 5 years and then come in. Obviously, emergencies happen, and that's very unpleasant, and that takes a lot of time and effort and funds to deal with, and inevitably you may lose part of it, you may save part of the inheritance, but proper planning way in advance is very, very important. And this is what irrevocable trusts, when properly drafted and done timely, really help you with. So we talked about the documents that are protecting you or your loved ones after your death. There are also documents that are specifically designed for the time of disability. This is the time, and in estate planning, we're not talking about physical disability, we are talking about a mental disability. If someone has certain physical ailments, but otherwise they're able to fully comprehend and understand the circumstances and be able to, one way or the other, execute the documents, that is fine. On the other hand, if someone is in full physical health, but they are suffering from Alzheimer's or dementia, none of the documents can be any longer executed. So you also have to account for this. If you have a loved one that is exhibiting an early onset of dementia, you got to get these documents drafted and signed by them as soon as possible. I cannot tell you how many times I've had clients coming to me and saying, mom's had dementia for 5 years, she just had a second stroke, and now it's full blown and she doesn't know where she is. Give me the power of attorney. And the answer is, I can't give you the power of attorney. I can draft the power of attorney, but mom is the ultimate client if she is the principal on the power of attorney. If she cannot sign it, we're done. There's no more conversation. And the alternative to all of this is guardianship, which is basically asking the court to grant you the same powers mom would have given you voluntarily, but now it's a whole court proceeding involving several parties, a lot of time, again, a lot of expenses, and the court may or may not even appoint you as an agent at the time, especially if there is an infighting with a family, if there's 2 or 3 adult children and they don't talk to each other, and each of them wants to take care of mom for whatever reason. Maybe they love her, maybe they just want her money. We don't know what's in their mind, but the court might just say, you know what, this is too complicated, and appoint a third person, usually an attorney, to be the guardian. And then no one's happy, because the attorney is doing their best work, but they're not there with mom, and then the infighting continues. So these documents that are listed here, power of attorney, living will, healthcare proxy, they are of utmost importance to you as a client while you're alive. And you have to execute them while you're alive and well. And they are for the time that you are alive, which means your assets are still yours. There's no inheritance. No one's getting your stuff, but you are no longer able to take care of your assets. Or it could be a scenario that you're simply unavailable or unable. If you have a light bill that needs to be paid, but you're traveling in Antarctica on a whale watching expedition. I'm not sure if the whales are in Antarctica or where they are, but I'll tell you this, you're not available for a week, someone has to come in, and then it could be your agent coming in and getting access to your money for your benefit. Again, not as inheritance, but getting access to your money in order to help you deal with your present situation. That's a power of attorney, for example. That's something that's very important. It's not just dealing with money, but it's dealing everything that's non-medical, meaning that they can file your tax return, they can maintain litigation, they can hire professionals on your behalf, as long as there's basis for it. You will notice that there's something called statutory gifts rider that is no longer being used. It's a very interesting creation of New York State legislature, because before, in early 2000s, our New York State powers of attorney really looked like every other state. It's kind of like a freewheeling form, and you kind of have to read and see what it says. But because in New York, there were concerns of rampant fraud and elder abuse, legislature created this form that, called the statutory power of attorney, which we still have in different permutations. It changed about 5 times between 2008 and last year, which is what we're using now. And the legislature at the time split up the power of attorney into 2 parts. There was an actual power of attorney that you can do everything you want to do, except you could not give gifts of your property. Well, your agent could not give gifts of your property of over $500 a year, which on one hand you could limit. And then if you wanted to give the gifts of your property, you would execute a rider. Literally, it's like a rider, like a lease rider, like any kind of rider, like a life insurance rider, that basically you said, okay, no, I am okay with my agent, I trust them, I love them, and they can give gifts. The problem was that a lot of attorneys who were executing powers of attorney, who were not elder law attorneys, who were not estate planning attorneys, didn't appreciate the rider. So they would execute the power of attorney, but not the rider. And then 5-10 years later, the client goes in the nursing home, they no longer can sign the rider, and the agent is limited in establishing a new trust in transferring their property for Medicaid planning. And that created a lot of issues. So the legislature did take into the account how useful the rider was, but also how confusing it was. So as of June of last year, the rider was kind of, they pretty much substantially kept the power of attorney the way it was. They just kind of shortened it. They removed some redundancies. They made some even more advantageous provisions. And then the rider in relevant parts was incorporated back in. So now it's, again, one unified form, but it's again statutory form. And you should be very careful executing it. But you should be aware of the rider, because the rider was legal when it was legal, when literally it was, if you, at the time, if you don't do the rider, then, then you don't have a rider. If but at the same time, because the form is statutory and that's what you're supposed to use, even though you could use something else, but all the banks were trained to just read now this one uniform power of attorney, and they rejected everything else. So if you used a wrong power of attorney in 2016, you used a 2005 power of attorney, there could have been an issue. So now no one's probably using the riders, but someone might if they're not aware of this nuance. And you also may encounter a power of attorney executed during that period before June of 2021, where you will encounter the rider, and you have to be familiar with what it is, especially if you are in financial in financial services sector or anything like that. That's very, very important. So the healthcare proxy is the flip side of power of attorney. As I said, the power of attorney covers anything that's non-medical. Healthcare proxy covers the medical. You appoint, it's legally binding, and you appoint your agent to make healthcare decisions for you. And a properly drafted healthcare proxy will include a HIPAA release, which will help the agent get access to classified privileged documents, medically privileged documents. Living will is a supplement to healthcare proxy, and that is something that you basically encounter at literally the end of life, where a client may tell if they have a funeral arrangements, or if they have cemetery plot, or if they want organ donation, or if they want burial or cremation. A lot of times burial and cremation are being put in a will because that's how it's traditionally been done, but it's kind of useless because by the time the will sees the court, it could be months, 2 months, or a years later. So the person is obviously already been, the death has already been dealt with. So living will is where you tell your family, your loved ones, and your doctors what would be your last, the wishes for your last days on earth. And if it's not legally binding, it's a good supplement, it's a good framework. It's good to have, just in case whoever you nominate as an agent is no longer available, if they predeceased you, if they're sick themselves, if they just don't want to deal with it, and it's a third person who's never met you in their life. This gives a nice framework. So when at the very, very basic level, when we meet the client, the very basic, what we call here a will packet, involves a last will and testament for after death, living will, healthcare proxy, and a power of attorney. These are your standard documents that you want to have. And again, remember that living will and last will and testament are two completely different documents. And when someone wants a will to leave their assets to someone, they're talking about last will and testament. So as I said, the statutory gifts rider has been was implemented in order to abuse power. I love this quote: power corrupts, absolute power corrupts absolutely. This is where the agent, I mean, there's been so many cases where grandma gives her grandson power of attorney to take care of her bills, just to have him come into bank and clean out her life savings and go party somewhere, and then claim that he didn't know he couldn't do it. He thought this was his inheritance. That is very unfortunate. So we discussed the living will and the healthcare proxy. And oh, there's a typo. It's HIPAA, not two P's, but one P and an A. I just want everybody to be aware that we need to change that. I know this was typed up, and I guess in a hurry. Okay, so just like the power of attorney and healthcare proxy have flip sides of the same planning, so is financial planning and estate planning. You have to consult both estate planning and financial planning professionals, because again, it's part of the planning. Usually when we're working on estate plan, there's three professionals involved. There's a estate planner, financial planner, and a CPA knowledgeable specifically in estate and financial planning. And it kind of limits the pool because a lot of CPAs do income tax, but not a lot of them go and do trust and estate accounting, for example. So it's very, very important to protect yourself by providing for long-term care insurance for yourself, maybe disability, life insurance. If you are a business owner, you want a key person insurance. If you have partners in the business, you want a buy-sell agreement that is funded. And the buy-sell agreement, a funded buy-sell agreement, is just an operating agreement with specific built-in provisions for life insurance in case one of the partners passes away or leaves, and the business should be, the business's ongoing concern should continue. Because so many times you would have, let's say, two business owners who are best friends, and they're always out together with their spouses, and then one of them dies. So now you have clear conflict of interest. The remaining partner wants the business to go on, and the remaining spouse of the decedent wants to cash in their chips and get as much money as they can from the business because this is all they have. So then that breeds infighting between people who were best friends for years, maybe decades. So to supplement the planning, you always want to consider specifically financial tools. And there are specific irrevocable trusts, for example, that can house a life insurance where you take it like a pilot, the irrevocable life insurance trust that would take life insurance ownership out of the name of the decedent. And that's sometimes also very, very important. So you kind of have to approach the situation holistically, anyone's situation, whether or not you or someone you know or your loved one is special needs or not, but you want to approach this holistically and see where you are in life and what you need to continue, what's going to happen in 10 years, 20 years, 50 years. Every situation is different, and obviously nothing beats the actual expertise of a professional. Special needs planning is very important, very, very important. It's a big part of our practice. And what is the special needs planning? You have a lot of times people create regular trusts, and a lot of times they create special needs trusts. That is a type of an usually irrevocable trust that provides for the benefits of a specific person that is receiving public benefits and cannot have money outright. So there is a trustee that is in charge of the money that somehow belong to this person with special needs. They may be elderly on Medicaid, and the trustee is empowered to supplement but not supplant the benefits. And that's the point. That is the entire point. You want, for example, Medicaid may cover, if you go to a dentist, Medicaid may cover a routine teeth cleaning, but then they may not cover a full out operation, something to do with rebuilding, and that's very, very expensive. So you do not want to pay for any service that Medicaid otherwise covers, because that will jeopardize you, and Medicaid will say, well, if you have the money, why are we giving you the money? But at the same time, you may have things that are not covered by, for example, Medicaid, and like anything outside of a routine teeth cleaning, that's a major dental surgery. And then the funds held in S&T play a big part, where you can have the trustee pay the dentist directly. And so the money never touches the hands of the person, of the special needs person, but they receive the full benefits, and it's obviously fully legal, and there's no cutting corners, there's nothing. It's full transparency, because that's what it's supposed to do. You're doing what you're supposed to do. Again, this is not for basic needs, because the basic needs are usually covered by Medicaid and other agencies that provide public benefits. This is for extra, again, like a vacation that these special needs person may take. And we say special needs person, it could be just the elderly person who is receiving Medicaid and otherwise qualifies monetarily, and things of that nature. You have first party and a third party S&T. S&T is a special needs trust. What is the difference? First party special needs trust is a trust funded with the person's own money. So for example, you have a person who has special needs, and they won a personal injury action. Maybe in fact they have special needs because they were in some sort of accident and that changed their life. So now they have all of this money, and they need to put it somewhere, and they can't hold it and say, look, I'm going to qualify, I'm going to live off this money. So you have what's called the first party special needs. That's the person themselves is the first party. The money is there during their lifetime and is exempt, and as long as they're in this properly drafted first party special needs trust, and the trustee again may use them for their benefits, for the beneficiary's benefits. There is a catch, that there is upon their death, yes, their beneficiaries can go their loved ones and whoever it is, but not until Medicaid payback provision is satisfied. First party S&T always has a provision that that Medicaid has a first creditor lien against the assets of the trust. If the assets of the trust were used up during the lifetime and properly, then that's what it is. But if they weren't, Medicaid has a tally of how much money they've expended on behalf of the now deceased person, and that money has to be satisfied to the extent that there's funds. If there's more funds in the trust than the Medicaid bill, then the beneficiaries get the rest. But it's usually, and again, this funds usually include inheritance and personal injury action, including medical malpractice. In third-party special needs trust, this is the trust that is funded by someone else and not the person with special needs. In this case, there is no benefit, there is no payback provision to Medicaid because it's not their money. It's essentially a gift that is delayed, or it's incomplete, or whatever you want to call it. That, for example, a parent of a child with special needs, understanding that the parent is a generation above the child, is leaving certain funds for the child's benefit, for the child to be taken care of by someone else, when parent can no longer take care of the child or they pass. So here you don't have a third party, a Medicaid provision like the first party does. And it's great because you can fund this with the life insurance, you can put cash, and because there's no Medicaid provision, any money left in this trust will just go to other beneficiaries, like the special needs person's siblings, for example. And again, that because it's a non-probate asset, it bypasses the court, and there's no court blessing required, and the money just goes outright in a private manner, and there's no public record. So these types of trusts are widely utilized in our practice, and we work with a lot of personal injury attorneys and Medicaid professionals. This is great. This is a very perfect vehicle if you or a loved one have special needs or are just maybe on Medicaid due to age. Guardianship, we touched upon a little bit. This is when someone does not have, never executed the power of attorney, and now it's just too late. Or if it's a minor, because minors do not have legal capacity to execute proper legal work, legal documents. So then you have to go to court and ask for permission. For example, if you have a minor who is either a minor or has special needs, and they inherited money, they do not have a legal capacity to take the money. And little known nuance is that a biological parent of the child is only automatically guardian of their person, which means they can take him to the doctors until they turn 18, but they're not automatically guardians of their property. So in order for the 12-year-old to accept inheritance, their parent has to petition the court to become guardian of property of the child, co-guardian with the court, because the court keeps a very close eye on what the parent does with the money, because the parent obviously wants to give the child the best childhood, especially now that they have the funds. And the court says, we actually would rather have this money preserved as much as possible until the child is an adult and can decide for themselves. So there is that give and take, there's push-pull, and that, but that comes in handy. And then there's guardianship, simply guardianship, mental hygiene mental hygiene law, MHL 81, and this is over pretty much any adult that may or may not even have funds, but may need help. And the key here is that the adult does not understand or appreciate their circumstances, and that they may be danger to themselves or others. In this case, you do need guardianship. And if this, for example, if this adult suffered from schizophrenia all their life, they may not understand, they may never have understood the power of attorney, or maybe they did, but they're resistant to it. So you would have to bring the matter to court and ask the court for permission to get guardianship. Unlike power of attorney, which is a supplemental document to a person's rights to basically control their life, guardianship is sort of like stripping adult of their adult rights and making them a minor child that you can take care of, and they no longer can make certain decisions without your permission. So this is a very, very drastic measure, and the courts do not grant it lightly, especially if the power of attorney is in place and it's not effective. So it's always better to have a power of attorney one way or the other than go through the guardianship, because it creates a lot of infighting and inconvenience for a lot of people. But as a last resort, it's a very powerful and fantastic tool in order to help someone. You also want to do a letter of intent and just supplement it with the plan. You kind of want to, whoever your plan is going to end up with, whatever you do, and especially considering, if the parent is aging out and the child is growing up and still can't express their wishes, or for whatever reason, you kind of want a letter of intent explain to this future third party what you were trying to do, what are the child's ailments, what are the child's needs, and just setting up the framework. All of this is designed in order to help a person with special needs to have as much a quality of life as possible. This is the most important. A person, no matter what, should have dignity, and they should be respected. And this actually provides, this is one of the tools that helps preserve the dignity. So this concludes our presentation. And my name is Vlad Portnoy. My office is located on 34th and 7th Avenue. We cover New York City and some upstate counties, and also northern counties in New Jersey. So if you would like to speak, we're always available. You can Google us. We're everywhere, and we would love to speak with you. And hopefully you found this presentation useful. Thank you very much.
Thank you so much, Vlad. That was incredibly informative and will be a huge resource for our consumers. Thank you.
My pleasure. Thank you so much for having me.